Welcome to iProledge. My name is Theja, your JIGL faculty. So here in this video we'll be covering your chapter 5 Law of Torts. Alright, chapter 5 of JIGL Law of Torts. First, what do you mean by tort? Before that, there are how many types of wrong? There are two types of wrong. Civil wrong and then criminal wrong. What do you mean by civil wrong? Civil wrong is the wrong that is affecting an individual. Okay, something that is affecting an individual, it is called as civil wrong. What do you mean by criminal wrong? Something that is affecting the society, it is called as criminal wrong. I hope the difference is clear. Civil wrong is the wrong that is affecting whom? It is affecting individual. Alright. And criminal wrong is the wrong that is affecting society. Alright. So now I will give an example. Now let's say there is a person, some random person is entering my building without my permission. So what is happening here? What kind of wrong is this, do you think? Isn't this a civil wrong where it is affecting an individual? Now, is there any contract between me and that person who is entering my land? Is there any contract? No, there is no contract. Is this breach of contract what has happened here? There is no breach of contract. Is this breach of trust? There is no breach of trust. This is called as tort. What is a tort? Tort is a civil wrong which is not a breach of contract or a breach of trust. The situation what I gave, was it a breach of contract or was it a breach of trust? It was neither. So then you put it in the definition of tort. But for it to be qualified as a tort, it has to be a civil wrong only. Alright? So civil wrong is a wrong that is affecting the private individual. That is affecting individual. And what is a remedy for this? It is compensation. In civil wrong, in criminal wrong, it is punishment, imprisonment. Here it is only compensation. Now you tell me, compensation. What do you mean by damages? It is compensation in terms of money, compensation. Now there are two types of damages, liquidated damages and unliquidated damages. What do you mean by liquidated damages? Now how does contract work? In the contract they would have given, if the breach happens, at that time this is the amount of compensation that will be paid. Correct? This is how contract works. Now when the compensation is fixed before, it is called as liquidated damages. Now compensation is not fixed before. Court will decide what should be the amount of compensation. That is called as unliquidated damages. Clear with this concept? So we saw the first concept. There are two types of wrong, civil wrong and criminal wrong. Tort is what? It is a civil wrong. Okay, which is not a breach of contract or a breach of trust. And what kind of damages will be paid in tort? It is unliquidated damages. Why? I told when there is a contract, they would have already fixed what will be the compensation. In tort, in the example what I gave, that is the example of trespassing. A person is entering my land without my permission. Was there any contract between me and him? Can I determine, oh, tomorrow this person is going to come and enter my land, so I will decide prior only that this should be the compensation? No, right? So court determines the compensation, that is called as unliquidated damages. So in case of tort, how is damages? It is unliquidated damages. It is a civil wrong which is neither a breach of contract nor a breach of trust, where the damages will be unliquidated damages. Clear all of you? Yes. So let us come to the material. So tort is wrong. It is a civil wrong. Okay. There are public wrong and private wrong. Civil wrong, Criminal wrong. So offenses against state which is punishable under penal wrong is called as public wrong, your criminal wrong. And then they have given certain definitions of what is a tort. So a tort is what? It is a, this is very important, elements of tort. What are the elements of tort? It is a civil wrong which is not a breach of contract or a breach of trust. Okay, where the damages, what is the remedy for that? It is unliquidated damages. Clear with these three elements of tort? Now tell me, is there any act for tort? Now we have Indian Contract Act, we have Indian Partnership Act, we have Transfer of Property Act. Like that, is there any act for tort? Is there any codified law? No, there is no codified law. It is based on common law legal system. We have two legal systems, civil law legal system and common law legal system. When we have a codified act, it is civil law legal system. When it is judge-made law, it is common law legal system. So tort is based on the common law legal system, where there is no codified act here. Yes. So tort is a civil wrong, not a criminal act. Next. What are different kinds of tortious liability? See, now liability against a civil wrong. What are the elements of tort we saw? When a tort should happen, what are the three things that we have to check? First, there should be a wrongful act, correct, no? So somebody has committed a wrongful act, or a person has committed a wrongful omission. That means what? He had to do something, but he did not do. Because he did not do, the other person has suffered loss. Okay, so either a wrongful act or a wrongful omission. To do something, you have done something, because of that some other person has suffered, or you did not do something. Because you did not do something, someone else has suffered. So both will be qualified as tort. Now there has to be a wrongful act or a wrongful omission, and because of your act, I have suffered legal damages. What do you mean by legal damage? My legal right is violated. Alright, so what should be violated? Legal right has to be violated, and for that, what is the, and for that I have some legal remedy. So to qualify as tort, three things: there has to be a wrongful act or a wrongful omission and this, because of this wrongful act or wrongful omission, a person should have suffered legal damages, that is violation of legal right, and there has to be a legal remedy for that. What is this legal remedy here? Unliquidated damages. So there has to be a wrongful act or a wrongful omission, there has to be legal damage. Now here there are two important maxims that you have to remember. The first maxim is damnum sine injuria, damages without injury. That means damages has happened, some physical damage has happened, but without violating the legal right. What is injury? Legal right. What is injury? Legal right. So some kind of damage has happened to me. It could be monetary damage or whatever, but my legal right is not violated. That means it is not a tort. So for any situation to be qualified in the definition of tort, for that your legal right has to be violated. Just damages, is it sufficient? No. So there is a very important case law, Gloucester Grammar School. So what happened in this case law? There was a school and there was a faculty. So the teacher of this school, what he did, he went away from that school, that is he left that school and started his own coaching institute. So all the students joined there. So here, this particular Gloucester school suffered a lot of damages, no monetary damages. There was loss because all the students left from here and they went there. They shifted there. Now, did any legal right violate here? No. No legal right got violated here. It was only some monetary damages that you had to suffer. So is this a tort? It is not a tort. So what is important in tort? Legal right of a person should be violated. Alright. Next, the next maxim is injuria without injuria sine damnum, that is injury without damages. Legal right is violated, but you did not suffer any loss, you did not suffer any damage. Is this a tort? Yes, it is a tort. Okay, I will give an example. There is a case law, Ashbury versus White. In this, a person was restricted from voting. He was not given a chance to vote. Did he suffer any damage here? Did he suffer any monetary damage or any sort of damage? No. But was his legal right violated? The right to vote? Yes, no, his legal right got violated. So is this tort? Yes, it is tort. So simple thing, what is important in tort? Legal right of a person has to be violated. If injury is caused, then it is tort. Just damages is not sufficient. Injury has to be caused. Very, very important two maxims that you have to remember. Alright? Next. So first is wrongful act has happened or wrongful omission. For that, legal damage, and then the third element is legal remedy. What is legal remedy? Unliquidated damages. What is the compensation in tort? It is unliquidated damages. Clear? Now, is mens rea important in tort? What is mens rea? Mens rea is guilty mind, which we see in criminal act. Mens rea is what? Intention, guilty mind. So there is a very important maxim. Actus non facit reum nisi mensit rea. What does this maxim mean? It means an act does not make a person liable unless that person has a guilty mind. You don't have any intention, you don't have criminal intention. So just because you commit an act without any intention, that's not a crime. So this is a maxim, but there are certain exceptions to that and everything. Here we will see whether is mens rea needed in tort or not. There are two cases. In certain cases, mens rea is needed. Court checks whether there was any intention, whether there was negligence. If yes, then it is a tort. If no intention, if no mens rea, then it is not a tort. In which cases courts see that yes, there has to be mens rea? In these cases, when there is any assault. Now this, I do like this. What has happened here? There is some sort of fear that is there inside you. So when there is any assault, court checks whether this person intended to cause that fear in him. If yes, then it's a tort. If no intention, just like that, I did like this, and when I did like this, you got scared, but I didn't have any intention to cause it, then court says that it is not a tort. Okay, so assault is my action causes fear. And then battery, I hit you. This is what? Battery. This action is assault, okay, where I'm causing some fear and I hit you. This is battery. And then here court checks intention. By mistake I hit. No, there was no intention. And then false imprisonment, where I am restricting a person's freedom of movement. Okay, so I lock a person by mistake. There was no intention, but I lock a person with an intention to restrict that person's freedom of movement. This is false imprisonment. So court says it is tort. Deceit, to deceive someone. Court checks the intention. Malicious prosecution, where some false action I have taken against you. False case I have filed against you. So court checks the intention there. And then conspiracy, where together we have come together to do some illegal act. Court checks what was the intention there. So in these cases, court checks the intention. Okay. Negligence, all of that is checked. If intention is there, then it is a tort. If not there, then it is not a tort. So fault or state of mind, when it is relevant, in these cases it is relevant. Okay. Next, cases where intention is not checked. That doesn't matter. If you had good intention, bad intention, I don't care. Court doesn't check. In two cases. First case is in the case of defamation. When I publish an article which has harmed a person's reputation, can I later say, no, I didn't intend to cause harm to you? No, you cannot say that. Can I say it was by mistake? No, you have caused harm to that person by publishing your article, this is, you have caused harm to that person's reputation. It is defamation. In case of defamation, intention is not checked. The second case, when a person's, because of a person, accident is committed, or that person has suffered permanent disability. Okay, in this case also court doesn't check intention. It says you have to pay compensation to the other party who has suffered loss. In two cases court doesn't check intention. Understood which cases court checks intention and the other case where court doesn't check intention. So mens rea where it is relevant and mens rea where it is not relevant. Okay. Next is your strict or absolute liability. Very, very important. So what it says here. See, some civil wrongs impose liability without proof of intention or negligence. They fall into three categories. Where they don't check intention or negligence, it has three categories. The first category is liability for inevitable accident. That means what? A person has kept some kind of dangerous element in his premises, and that dangerous element has escaped his premises and caused harm to other person. So here intention is not checked. You have put a dangerous element in your premises and that has escaped your premises and hurt and caused harm to others. So we will not check the intention here. Okay. Intention, negligence is not checked here. So you are keeping that dangerous element there at your own risk. You are responsible for that. Next is in liability by inevitable mistake. It is causing harm to others' reputation. That is in case of defamation. And then vicarious liability for wrong of others. What is vicarious liability? When a person is liable for the act committed by others. Okay, we will understand vicarious liability now. As of now, remember, master-servant relationship is there. For any wrong that is committed by the servant, who is liable? Master is liable. Okay. Wrong is committed by whom? Not by the master. It is committed by servant. But who will be liable? Master. This is vicarious liability. For others' act, I am liable. Okay. So there is a very, very important case here. Ryland versus Fletcher. What happened in this case? Now in this case, the very, very most important case where the concept of strict liability was there. Okay. Here the concept of strict liability got introduced. So what happened here? In this case, the rule that was laid down was, if a person brings or accumulates on his land anything likely to do mischief, that is disturb, if it escapes, he must keep at his peril. If it escapes and damages another, he is strictly liable, however careful he may have been. The same thing what I told here. That is, when you keep any dangerous element in your premises and that dangerous element causes any mischief to others, it escapes your land and cause harm to others, that means you are fully responsible. We impose strict liability on you. Doesn't matter if you have any intention, doesn't matter if you were negligent or not. Even if you were very careful with that, liability will be strictly imposed on you. This is what was held in the case law Ryland versus Fletcher. Very, very important case law of tort. Okay. So the defendant is treated as an insurer of the neighbor's safety in this case law. That was a principle laid down. Okay. Understood? So here they told that in Reed versus Raylon, to apply strict liability, two things needs to be checked. What are those? Escape from the defendant's control. Okay, it has to move from defendant's land. Just keeping is not harmful. It moves from defendant's land to other premises. At that time you have to apply the principle of Ryland versus Fletcher. This is the first thing. What is the second thing? There has to be non-natural use of land. Now you are using land for a particular purpose for what it is supposed to be used. At that time Ryland versus Fletcher principle will not be applied. When will we apply strict liability? When you are using the land for some purpose which it is not supposed to be naturally used. Keeping chemicals on the land. Is is it the right purpose of usage of land? No, right? So if these two conditions are there, then we will apply the principle of Rayland versus Fletcher. Which two conditions? First is there has to be escape from the defendant's land, and the second thing is non-natural use of land. Okay, now this is the concept of strict liability, and they later told that there are certain exceptions to strict liability. That is, strict liability will not be applicable in these 6 cases. First case is damage is due to natural use of land. That is, we did not do it, we have used the land for the purpose it is supposed to be used, and still damage happened, then strict liability is not imposed. Okay, first is what? For what purpose land is supposed to be used, we have used it for that purpose only, still damage happened. Okay, at that time we will not use the principle of strict liability. Second, we have taken consent of the plaintiff. Plaintiff has agreed, so at that time also not applicable. Act of third party, damage is caused because of a stranger, not because of defendant, at that time not applicable. Statutory authority, statutory authorities are given exempted from strict liability concept. And then act of God, because of earthquake or any unforeseeable situation came up, so because of that damage has happened, strict liability is not imposed. And then plaintiff's own default, because of plaintiff's fault only damage happened, so strict liability will not be imposed. These are the most important 6 exceptions where strict liability concept will not be imposed. They can take defense. Understood what is strict liability? Strict liability, you have, if at all the question is asked on strict liability, you will be writing the rule of Rayland versus Fletcher and Reed versus Lyon, and then what are the exceptions that are given. Alright, next, now this is English law. Now a concept got introduced in India, that is absolute liability. Okay, so what is absolute liability? Now in strict liability they are telling, to qualify as strict liability there are 2 conditions that needs to be satisfied. First condition is escape, second condition is non-natural use of land. But in absolute liability they are telling, no condition. You have bought in some hazardous chemical or hazardous substance on your land. That means without any other conditions, if that land, if at all that hazardous substance escapes from your land, then you are absolutely liable. No exceptions, nothing, no benefit, nothing. You cannot say negligence, you cannot say non-natural use of land, nothing you can say. You have kept a hazardous substance on your land. At that time, absolutely you will be liable. Strict liability is not strict. The stricter of that is absolute liability, where absolutely you will be liable without any exception, nothing. Alright. So it was laid down in the case law MC Mehta versus Union of India. So in this case law, what happened? A person is absolutely liable, defendant is absolutely liable when the enterprise must ensure that no harm results. It must compensate fully for any harm without needing the victim to prove negligence. Here, should victim prove negligence or anything? No, absolutely that person is liable. Alright. So in this case law, the court held that when any enterprises engaged in hazardous or dangerous activities, then you are absolutely liable. Very, very important. I hope everyone understood the difference between absolute liability and strict liability. Got the difference between the both? Yes. So this was the principle laid down in MC Mehta versus Union of India. 2 most important case law, that is Rayland versus Fletcher case law, which talks about strict liability, MC Mehta versus Union of India, which talks about absolute liability. Alright, and the other 2 case law that we saw was Gloucester Grammar School case and Ashbury versus White. Now case laws are very important in this chapter taught. You have to remember the case laws, okay? Yes. Now, what is vicarious liability? As I earlier said, A person is liable for the act committed by another. What did I say? A person is liable for the act committed by another. Okay, I didn't commit the act, but still I am liable. We will see when. So there has to be a special relationship. Of course, no, when you are making me liable for someone else's act, mine and his, there has to be a special relationship. What is that? There has to be master and servant relationship, or there has to be principal and agent relationship, or partners in a partnership firm. Partners, we'll understand that. Before that, a person may be liable in respect of wrongful act or omission of another in ways as given under. How will I be liable? How will one person be liable for the act of another? In three ways. First is by ratification. What is ratification? The act is already, it has happened. I am approving an act that has already happened. Okay. So I ratify. That means I will be liable. An employee has done something without the authority. I later approve that. Okay, whatever you have done, I ratify it. So now I will be liable, right? Employer will be liable. Next is by relation. There is some special relationship between us. That is, it could be master and servant relationship, employer and employee relationship. There is a special relationship. And one thing what you have to remember here is that relationship should be during the course of employment, not past relationship. It has to be during the course of employment. Okay, this is very important here. So there has to be an existing relationship, very, very important. And the second is, in case of employer and employee, it should be during the course of employment. There is 9 to 6 is my employment. During that course, employer is liable for the act of employee, not what he does in his home or whatever. Okay, later whatever he does, is employer liable for that also? No, it is during the course of employment. Okay. So second is by relation, third is by abatement. That is, if I assist a wrongdoer, at that time even I will be liable. If I help the wrongdoer, even I will be liable. These are the three ways where vicarious liability arises. Now, what are the different types of vicarious liability? Very, very important. First is, there has to be principal and agent relationship. Of course, no. So if an agent commits any wrong, who is liable? Principal is liable. Okay, this is very important. There is a maxim, cui facit per alium facit per se. You have to remember all the maxims here. He who acts through another acts himself. So the principal's liability is coextensive with that of the agent. That is, whatever is the liability of the agent, the same is the liability of the principal. That is what you call it as coextensive. Next, partners. Of course, each partner is an agent of another partner, and each partner is an agent of the firm. So when partner commits any wrong during the course of employment in the name of the business, so is other partners also liable? Of course they are liable, because they are agent of each other. And how is their liability? It is joint and several. Okay, that is what you have to remember here. Liability is jointly and severally. Next is master and servant. Very, very important. Again, cui facit per alium facit per se. So here the master is liable for the tort committed by his servant while acting in the course of employment. This is what you have to remember here. After business hours, not liable. During the course of employment, whatever the employee does, employer will be liable. Okay. And then this is very important. Employer and independent contractor. What do you think? There is an independent contractor and there is an employer. Employer has hired an independent contractor. Now, if any wrong independent contractor commits, is this employer liable? What do you think? General rule is, you cannot make employer liable for the wrong committed by independent contractor, because there is no employment-employee relationship there. He is an independent contractor. There is no salaried relationship. Correct, right? But in certain cases, we will make employer liable. What did I say? The general rule here is, employer is not liable in case of a wrong committed by an independent contractor. But in certain cases, employer is liable. First case is when employer expressly authorizes the independent contractor to commit any wrong. When he is only telling that you have to do some wrong, at that time employer is liable. Second, in case of strict liability, when there is strict liability or absolute liability, does court say think that okay, this person is an independent contractor or not? No, you are strictly liable, you are absolutely liable. There was some hazardous substance here. Even if some wrong committed was, even if the person who committed wrong was an independent contractor, it doesn't matter. There was a hazardous substance there and it escaped your land either because of independent contractor or because of you, doesn't matter. You are liable. Okay. So the third case is negligence of contractor. So wherever contractor's negligence occasions harm in circumstances where employer owed the victim a non-delegable duty, employer had a duty to inform the other persons, but because of his negligence, he did not inform the other person. Independent contractor committed some negligence, so employer is liable. Employer had a duty to inform, but employer did not. At that time, employer itself is liable. Understood? What is the general rule? When there is an employer and independent contractor, employer is not liable in case of a wrong committed by independent contractor, but in these three cases, employer is liable. Alright. So when he is not liable, if the employer used due care in selecting a competent contractor and none of these three exceptions are applicable, none of these three exceptions are there, it doesn't fall under these three exceptions, and employer had taken proper due diligence, he did a proper due care and he selected a competent person as an independent contractor, at that time employer is not liable. Understood? Alright. The next is servant or employee specific rule restated. The same thing. So here employer is liable whenever the servant is in the course of employment. Two things. Commits either a wrongful act that employer authorized. Now the wrongful act, who has authorized? Employer has only told you should do some wrongful act. At that time, who will be liable? Employer will be liable. Or during the course of employment, employer told you do this act, but the way that employee did was wrongful. Even in that case, who will be liable? Employer will be liable. Why? Because it happened during the course of employment. There was a driver who was appointed by the employer, and the driver work was to deliver the goods. This was what he was authorized to do. But the way he drove was very rash and it caused accident. Now who will be liable? Employer will be liable to pay compensation, right? Because it happened during the course of employment. So this is your vicarious liability. Very, very important. I hope everyone is clear. Next is vicarious liability of state. When will you make state liable? When will you make government liable? Now here you have to see two things. Is government performing sovereign function or non-sovereign function? This is what you have to check. If government is performing sovereign function or non-sovereign function. What do you mean by sovereign function? See, sovereign functions are those functions which only government can perform. Police authority, as a police authority. Can a private body be a police authority? No, right? So there are certain functions which only government can perform. That is sovereign functions. Non-sovereign functions is those functions which both private bodies and government can perform. It is non-sovereign function. Now, if the government is performing sovereign function, at that time can we make government liable? No. Vicarious liability is not applicable. When the government is performing sovereign function, vicarious liability is not applicable. We will give them immunity when it is performing sovereign function. But when it is performing non-sovereign function, during that time some wrong happens to the other person. Is government liable? Yes. When it is performing non-sovereign function, at that time state is liable. Clear all of you? So there is a very important case law. The case law here is State of Rajasthan versus Vidyavati. So in this case law, what happened? There was a collector and he had a driver and his vehicle. So his driver was driving the vehicle and it caused accident to some person. Here the question was, will state be liable or not? You only tell me, will state be liable? For that you have to check whether the state was performing sovereign function or non-sovereign function. In this state was performing non-sovereign function. Correct, no? So will the state be liable? Yes, the state will be liable. Understood? Now, the second example in Kasturi Lal versus State of UP. What happened in this case? In this case, it so happened that the police thought that there was a person. The police thought that this person is a thief and he took away all the jewelry, whatever was there. So the police was performing the police duty. During that course, and later they got to know that this person whom we have arrested and the jewelry, whatever is there, that person is not the thief. Now, later they get to know one of the constable has ran away with that jewelry. Now that jewelry, what actually belongs to that person, is not there. Now you tell me, will state be liable for the act of this police? What do you think? Will state be liable? In that case, what? Will state be liable? The question there was, will state be liable for the act of the driver? What was the answer? Yes. Why? Because the government was performing non-sovereign function. Here, will state be liable for the act of the police? No. State will not be liable for the act of the police. Why? Because the government was performing sovereign function. That is why state will not be liable. All of you clear till here? So here, what is it that you have to check? You have to check whether the state is performing sovereign function or not. If it is performing sovereign function, then it gets complete immunity. Vicarious liability is not applicable. But if it is not performing sovereign function, at that time we will make the state liable. We will make the state vicariously liable. Alright? So clear till here? Very, very important. We have again seen another two most important case law. And then comes our next part, that is tort or wrong to personal safety and freedom. So an action for damages may be brought for the following wrong, each of which is treated as an injury to a person of an individual. What are those? First is battery. What is battery? Hitting someone. I cause physical harm to someone. That is called as battery. So it is direct application of force to a person of another without his consent or lawful justification. So here two things are needed. You have to use the force, however trivial, without the plaintiff's consent and without lawful justification. This is called as battery. Alright. Next is what? Assault. Assault is what? This is assault, where I didn't hit you. Physical harm I did not cause, but I have created some fear inside you. This is called as assault, right? So what is assault? It is causing fear of immediate physical contact. Okay, I am causing a fear in you that you know that the next minute you will hit me. So this is assault. And then bodily harm, a willful act or a statement calculated to cause physical harm, and in fact causing such harm amounts to bodily harm. Next, false imprisonment. I am confining, I am restricting your freedom of movement. So the total restraint for a period, however short, upon the liberty of another without sufficient lawful justification. Without lawful justification, I have locked you inside your room. There I am not letting you move. Your freedom of movement has been taken away. This is false imprisonment. Then malicious prosecution. Malicious prosecution is very important. You have to remember the essentials of malicious prosecution also. So what is this malicious prosecution? First thing is prosecution by the defendant. So the defendant must have initiated or actively caused physical or criminal or judicial proceedings against the plaintiff initiated criminal proceedings or judicial proceedings against the plaintiff. Next, no reasonable or probable cause. Without any proper reason, you have initiated judicial proceedings against that person. What is it? Without any proper reason, I know that person is right. Still, I am initiating false case against that person. Now, the defendant acted with improper motive. The motive with which that person acted was wrong, because I know that person is right. Still, I am filing false case against that person. And because of that, damage has been caused to plaintiff. Of course, no. Loss of reputation. Definitely loss of reputation or loss of personal arrest, personal detention. So that person was arrested for that short duration. That is a harm that person has been suffered. So, and then loss of property or financial loss. So some kind of damages that person has suffered. And proceedings ended in plaintiff's favor. The case must have ended in acquittal or discharge of the plaintiff. That person is discharged. So in simple, what happened? A person has initiated some false case against that person, and because that person initiated false case, the other person has suffered damages. It could be loss of reputation, loss of property, loss of personal liberty, all of that, and that person is released from that case. Court has told, you did not do any mistake, we are releasing you. At that time, that person who is released, can he file a case against this person? This is called as malicious prosecution. Understood, all of you? Yes. Next is nervous shock. Now the person does something and it has caused severe nervous shock to the other person. This is a tort. Okay. So provides relief where physical injury is caused not by direct impact but by nervous shock resulting from what the plaintiff saw or heard. So A acted negligently by driving onto railway tracks, creating a dangerous situation when the train was about to pass. This caused severe nervous shock to the other person. So you have done something publicly that has caused harm to nervous shock to the other person. Isn't this a tort? It is a tort. Okay. Next is defamation. We have already seen defamation. What is defamation, guys? It is loss of reputation. Okay. Now defamation can be of two types, right? It can be either written or oral also. So defamation is what? Publication of a statement that tends to lower a person in estimation of right. We have two types, libel and slander. What is libel? Something in written, through pictures, in writing, you spoil someone's reputation. You write an article on that. That is what? Libel. What is slander? You are giving a speech and there you harm someone's reputation. That is what? Slander. Okay. So libel is punished more severely. Reason being, you are publishing an article in newspaper. That is something you can never erase it. It is permanent, right? So there is no justification for that. So it is more punishable. All right. So this is about defamation. And then the next is negligence. What is negligence? Negligence is carelessness, right? Failure to act with a level of care that a reasonable person would exercise in similar circumstance. So how does court determine whether this person was negligent or not? Court sees, okay, this is a situation. Now how a normal person would act in this situation? That much care you should have taken. But you did not take that much care. That means you have acted negligently and this amounts to tort. Okay, so court checks how a normal person would have acted in this situation. If you had acted that way, then you were not negligent. But you did not act in that way. That means you were negligent. So this is about negligence and these are the things that amounts to tort. All right. And then what are the remedies in tort now? What are the remedies? We have two types of remedies, judicial remedies and extrajudicial remedies. What is judicial remedies? Remedies given through court. Extrajudicial remedy is outside the court, the remedies that we have. That is extrajudicial remedies. Now we will see what all come under judicial remedies. Under judicial remedies, we have first one is damages. Second is injunction. Third is specific restitution of property. What are the three things? Damages, injunction, specific restitution of property. What do you mean by damage? We have seen this multiple times now. Damages are monetary compensation. What is it? Monetary compensation. Now damages again, how many types they are? Liquidated, unliquidated. In tort, is it liquidated damage? No, it is unliquidated damage. So damages are monetary compensation awarded to plaintiff for the loss suffered. The objective is to compensate the injured party, not to punish the defendant. Again, who will determine how much should be the damage, how much should be the monetary compensation? Court determines. So damages is the first remedy. The second remedy is injunction. What is injunction? In simple, injunction means stay order. When court asks you to stop doing something or court wants you to do something, both time court passes an injunction order. Okay, so injunction is the court order directing a person to do or not to do a particular act. It is discretionary remedy. It is as per court's discretion whether to grant or not. So based on the facts of the case, court grants injunction. This is one of the remedy. All right. Next is specific restitution of property. Third remedy. What is specific restitution of property? Now let's say I have this water bottle. You have taken this water bottle from me. I tell, give it back to me. Restore the property. This is called as specific restitution. Give back my property to me. Restoring the property. This is specific restitution of property. This is also a remedy which court grants. Whatever property you have taken from that person, restore that. Okay, give it back to that person. This is specific restitution. So this remedy involves restoring the property to its rightful owner. It is applicable when the property is wrongfully or unlawfully dispossessed. Give it back to that person. Okay. So these are your three judicial remedies under tort. What are the extrajudicial remedies that there are there? See, extrajudicial remedies are lawful self-help remedies. Okay, court doesn't grant this. You help yourself. To protect yourself, we have given some extrajudicial remedies. Okay, where you can protect yourself. What is the first thing? Self-defense. Yes, it is an extrajudicial remedy. If someone is causing harm to you, use reasonable force to defend yourself. That is self-defense. You should not cause intentional harm to the other person. Use a reasonable force to protect yourself. This is self-defense. Now self-defense is extrajudicial remedy. Second, prevention of trespass. When somebody is entering your land without your permission, use reasonable force to push that person. Okay, use the reasonable force so that that person will not enter your land. This is an extrajudicial remedy provided to you. Okay, a self-help remedy. Second, re-entry on land. Some trespass is what? I am there in my land and somebody is wanting to come inside my land without my permission. That is trespassing. Now re-entry of land, there is someone who is sitting in my land and that person is not letting me come inside my land. So I can use reasonable force to re-enter in my land. This is re-entry of land. So yes, you can use reasonable force. Alright. Next is abatement of nuisance. When some nuisance is being created, can I remove that nuisance? Some nuisance is created for me. There is some disturbance that is happening. Can I remove that nuisance part? Yes, without harming the other person. Correct, no? So abatement means what? Removal or termination of the nuisance by owns act. It applies only to private nuisance. So for example, if branch of excess tree overhang wise land, it's causing nuisance, no? So can I remove that without disturbing the other party? Yes, I can do that. This is abatement of nuisance. Next is distress damage visit. This remedy allows seizure of moving property causing damage. There is an animal that is entering my land and causing harm to me. Can I retain that animal until I get compensation from the owner of that animal? Yes, I can do. There is some property that is causing harm to me. Can I retain that property? Can I seize that property until the other party pays compensation to me? Yes, this is a extrajudicial remedy. So this is your tort. So we are done with tort. All right. I hope everyone was clear with this. Clear till here? What is tort in detail we have covered. A very simple chapter, but a very, very important chapter. So complete entire revision of tort is done. Like this only we will cover revisions of all the chapters. Yes, thank you. Do share, like and subscribe to our channel. If there is anything, please comment down below. Thank you.